So I'd like to begin just by thanking Marcelo and Florencia Morato-Wergler for organizing this. Florencia can't be here, so thank you. For the next 2 days, we will discuss the legacy of Ronald Dworkin. Marcelo asked me to provide some opening remarks about Ronnie, who was my colleague and friend for 35 years. I readily accepted, but only when I sat down to prepare these remarks did I realize how difficult and intimidating it would be to talk about Ronnie, because Ronnie was the best talker of his generation, and probably your generation and the generation after, right? He was an exceedingly good talker. The stories of his fluency abound. The most famous in the U.S. concerns his Tanner Lecture at Stanford University, at which the president of the university, after introducing Ronnie and taking his seat, noticed that he had accidentally removed not only his introductory notes from the lectern, but also Ronnie's lecture notes. The absence of the notes, of course, had no impact on Ronnie's eloquence. A more impressive story, to my mind, that's famous here in Argentina, happened, actually, I believe, in this room 30 years ago. So Carlos Nino had invited Dworkin, Owen Fiss, Tom Nagel, Tim Scanlon, and Bernard Williams to Buenos Aires to counsel the government and to observe the trials of the military junta. They were also invited here to the law school, and 20 minutes after Dean Buligan welcomed them to his office, he told them, to their surprise, it was time to go. They learned that they were to talk to a group of people, and when they entered this room, they saw it full, this particular room. When I actually learned this story, I grew somewhat more intimidated by the fact that I was going to have to speak. The 5 visitors nominated Ronnie as a speaker, and he proceeded to talk extemporaneously for 45 minutes. I presume he spoke in English, not Spanish. It would be even more impressive if he had done it in Spanish. So let me note first that thankfully Marcelo forewarned me that I was going to have to make these remarks. And second, fortunately for you, I will not talk for 45 minutes. Ronnie's true gift and true pleasure were dialectic, just as they were Socrates' true gift and pleasure. And Ronnie's central question, just as it was Socrates' central question, was how should we live? So I want to talk a little about this gift of Ronnie's. It permeated his life. Its public manifestation was the colloquium on law, philosophy, and social theory that he and Tom Nagel convened for 25 years. The format ideally suited Ronnie's tastes and talents. At the center was the formal colloquium itself, in which Ronnie and Tom, later assisted by members of the audience, grilled for 3 hours the author of the paper under examination. But this public event was framed by 2 more private ones, which were even, I think, better suited to Ronnie's style. At 11:30 of the morning of the colloquium, the author, Ronnie, and Tom met in Ronnie's office for a preliminary but intense 3-hour discussion of the paper. Ronnie and Tom wanted to make sure that they understood the paper and that the author understood the issues that they would raise in the public session. Ronnie's aim here, as in all his dialectic encounters, was not to humiliate his antagonists, though Ronnie certainly liked and almost always succeeded in winning arguments, but to get the argument correct. Thus, though one might feel frustrated at the end of the dialectic encounter with Ronnie, one never felt disrespected or abused. His and Tom's questions identified exhaustively the argumentative fallacies and gaps, but never did so spitefully or dismissively. They came to improve the paper, not to bury it. The third stage of the colloquium, which happened, fortunately, from my point of view, for outside authors only, was a private dinner at which the discussion continued over food and wine. Ronnie believed that philosophy was best done over a bottle of wine. The better the bottle, the better the philosophy. And maybe I should have told Marcelo about this particular thing in advance. This part of the colloquium was always the most relaxed, at least for guests other than for the already exhausted author. And it was also the most entertaining, for here one gained insight into the less academic aspects of the guests. Who would have guessed from his works the wry humor of Jürgen Habermas, or the perfect pitch of J.A. Cohn's imitations of Ronnie and other contemporary philosophers? Dialectic also characterized Ronnie's teaching. I learned this from experience. I met Ronnie in spring 1977, the second semester of my first year of teaching. Ronnie immediately accepted the challenge I posed, a Sisyphean one, it turned out, of teaching philosophy to an economist. Ronnie was both patient and indefatigable in his efforts, and apparently undismayed at his lack of success. In his office and in class, or when conversation turned to philosophy over lunch or dinner, Ronnie patiently tried first to improve my capacity for argument, and secondarily to convince me that his position, rather than mine, was the correct one. Whatever the battlefield, I generally lost the argument, but remained unpersuaded. Ronnie also taught, sort of formally, dialectically. In the years before the colloquium began, Ronnie taught seminars, and at least once the basic constitutional law class. I twice had the pleasure, perhaps more precisely the experience, of co-teaching a class with him. The first time the topic was basically Law's Empire and the Hart-Dworkin debate. I played the role of Hart, and as you may imagine, things didn't go well for me. But I remember most vividly from that class Ronnie's interaction with two students during the break. These two students were part-time LLM students, a classification that no longer exists, and they habitually arrived late to and unprepared for class. That day, they approached Ronnie during the break in the middle of the class with a question that revealed that they had not understood the argument for several weeks. Calmly and patiently, Ronnie began at the beginning with a question, then another question that gradually led the students towards understanding. With a few olive trees and some warmer weather, I might have thought myself in the Athenian market, listening to Socrates interrogating these substitutes for Meno's slave. So I mentioned Carlos Nino earlier. I did not know him, though I did have the pleasure of attending a debate arranged by Ronnie and Tom between Nino and Roberto Unger. Sort of a transformation of the Argentina-Brazil rivalry from the soccer field to the seminar room. Since I'm in Argentina, you can probably guess who's going to win this particular encounter. Nino and Unger differed not only philosophically, but also stylistically. Unger liked oratory, while Nino, like Ronnie, loved to debate. Indeed, Ronnie and Nino shared a passion not only for argument, but also one for justice as well. As judging from those of Nino's students that I know, they also shared a personal charisma that has touched, influenced, and framed their work. So I think it's appropriate that we be meeting here in this room to talk about Ronnie's legacy, but I also, given the people here, is to some extent, I think, Nino's legacy in play as well. As we discuss the legacy of Ronald Dworkin today and tomorrow, I know I shall miss the probing voice that unrelentingly and passionately challenged each step in the argument. But I also recognize that Ronnie's intellectual legacy does not lie in the words on the page, the many pages that he wrote, but in the debates, the extensions, refutations that they inspire and provoke. Ronnie's legacy and Nino's legacy too is in part what will happen in this room during these 2 days. If that legacy is to live on, as I believe it will, it must not live on in the yellowing pages in libraries or as coded bits in digital storage, but in the cut and write post of discussion in seminar rooms like this. Thank you.
Thank you. Is this working? Yeah. First of all, in the name of the Dean Monica Pinto, I want to welcome all of you here. Monica is not in the country, and that was the first. Second, as Luis said, there is a long story of relation between Dworkin and this law school. The first time he was here, as Luis said, was in the year '85. And then he came several times again. The last time was in the occasion of receiving his diploma as an honorary doctor of this law school, and there he gave a speech about the philosophy of international law. And then he had a very long discussion with 6 or 7 generations of jurists and philosophers. And also, and most importantly, his ideas have really had an enormous influence in the teaching of the law, and as we will see in several papers, in the decisions of our courts, and in the best of our politics, democratic politics, we can find traces of the most important ideas of Dworkin. For this conference, we are very lucky to have 16 papers which cover an ample range of subjects. Konhauser and Isakharov call legal theories to move from the analysis of the concept of law to the analysis of governance structures. Then House, Farrell, Montero will speak about the pluralist challenges to Dworkin theory. Maris Iglesias, Jacob Weinrib, Roberto Saba, Laura Clérico and Martín Aldao, Ronaldo Porto Macedo, Professor de Lima Lopez. We'll talk about the interplay between Dworkin's categories and some continental conceptions of the law and try to relate them. Eduardo Rivera Lopez will talk about the limits of autonomy as understood by Dworkin in several problems of, in the area of bioethics. Carlos Rosenkrantz will place some doubts on Dworkin's view of political obligation. Ruti Teitel will connect Dworkin's idea with the important subject of transitional justice. We are not here to discuss in detail what Dworkin said in that page or in that footnote. We propose that we go directly to the ideas. I think this is the best tribute we can pay to that great man that was Ronald Dworkin. Discuss ideas and search for truth and justice. Thank you.
Good morning. Good morning to everyone. We are very honored to have in this panel, which name is Positivism, Conventionalism, and Interpretation, very distinguished professors coming from the United States and Brazil. Although you know, most of you know them well, I will briefly introduce them. Ronaldo Portomacedo is professor at São Paulo University, and the title of his presentation is Dworkin's Critique of Legal Conventionalism and Its Relevance. José Reinaldo de Lima Lopez is also a professor at São Paulo University, and the title of his presentation is Definite Law Does Not Require Interpretation Except for the Experts. And Louis Kornhauser, who is professor at New York University, he's going to talk about doing without the concept of law. Professor Portomacedo will start with this panel with a strong Dworkinian position, and then we follow Professor de Lima Lopez with a criticism to a Dworkinian thesis, and situating Dworkin account in a broader theoretical map. And Professor Kornhauser will try to show us why the work of most of us is based on a mistake. And if each of you will have 20 minutes for your presentation, and then I will give you the opportunity to make you each other questions, and then we'll have an open discussion. So, whenever you want to start.
Well, thank you very much. It's my pleasure to be part of this event and this celebration of Ronald Dworkin's work, which I think is very important for my own research, as well. It's very important and influential in Latin America. My paper, I won't read it because otherwise, I won't stay in 15 minutes that Marcelo allowed me to speak. But my paper is basically a sketchy way of organizing what I think is the basic point of Dworkin's criticism to legal conventionalism. And I think that the most important, and it's part of a bigger work, so it's a kind of introduction to the issue. Of course, there are many other important dimensions of this debate between interpretivism in the Dworkinian perspective and legal conventionalism that should be introduced in this discussion whenever we try to compare the arguments and counter-arguments that were produced in this arena. However, my point is not this. It's basically to make, to show in a sketchy way how this debate is organized and why I think it's important. Well, first of all, I think it's important, especially in Latin America and Brazil, because Dworkin's ideas are being consumed by legal academia, by jurists and practitioners in many ways. Most of his works have already been translated into Portuguese and Spanish. However, the way most of the practitioners understand and consume him and read him is far from being accurate, in my view. And one of the most important relevances of this sometimes fast way of consuming his ideas is connected to the fact that most or many practitioners and constitutional lawyers or professors of constitutional law basically pick part of his idea of his conclusions and separate them from the methodological and theoretical assumptions. And I think that what Dworkin has made in a very clear and insightful way is to bring to the legal discussions many very difficult and very complex and sophisticated philosophical arguments. So one of his genius was to being able to speak to lawyers the language or the kind of debate that was very present in the philosophical dominion, in the philosophy departments of many universities. However, it's always risky and dangerous, and it's not easy to make this kind of translation. And I think that one important point in his criticism and his contribution to legal theory is connected to this point, how his criticism to legal conventionalism in a way forced his adversaries, his theoretical enemies, to restructure some of their basic arguments on one hand, and in this sense shows how important his ideas were, even for those who didn't really agree with him. And on the other hand, I think that missing some points in his criticism also it's very important for those who in general agree with his ideas, because, or think that they agree with his ideas, because they are missing some important points of his ideas. Well, let me go straight to my point here. I think that one important criticism, what I call the Dworkinian challenge to legal conventionalism, is the fact that, according to him, the sources of law shouldn't be seen as based on conventions, and conventions understood as practiced social norms that function, which normativity, that means which the very way they function as norms depend exclusively on how they are being practiced. So this is what many scholars, like Positivismo, for example, call the foundational conventionalism. So legal conventionalism states the thesis according to which the nature of law and its normative force are grounded in social practice alone, directly. I think that this point was not even clear, so clear for H.L.A. Hart in The Concept of Law. Hart made a kind of conventionalist turn only in the postscriptum, where he clearly accepted this track for grounding his whole theory. And I think it's also important because even though there are many legal positivists that do not really endorse the conventionalist perspective, I dare say that the mainstream move in legal positivism is based on some variant way of conceptualizing this conventionalist dimension. Of course, we should ask, when we can ask, why is this important for theory and for practice? And there are many important authors. One of them is on my side, who really challenge the relevance of this kind of debate. I think there are some theoretical relevance, in the sense that giving a conventionalist or a non-conventionalist explanation for the grounds of law affects directly how we can well describe and properly describe what the law is. So there is a theoretical input on this and usefulness. But in my view, there's also a practical utility and usefulness for this kind of debate. And according to Dworkin, there is also a very important practical dimension. And Of course, this practical dimension can be understood in many different ways. For example, some people can think about the importance and relevance of legal theory because it functions as a kind of conceptual laboratory that feeds legal dogmatics with useful categories that are useful to solve practical conflicts. In this sense, we could say that legal theory would keep with legal dogmatics a relation that is analogous to that we can find, for example, between theoretical physics and civil engineering as a discipline. It's a kind of conceptual laboratory. This way of affecting the practice, I would say, would be still an indirect way. And according to Dworkin, there is a more direct way in which the discussion about the grounds of law, the very concept of law, is relevant to legal practice. Even though many important authors challenge this claim. For example, Ras or Posner would challenge the relevance of this theoretical dimension. And in order to present why and how this discussion about the grounds of law and the fundamentals of and the very concept of law, and especially the methodology through which we can respond to the question about what law is, it's connected to what Dworkin has called theoretical disagreements. Theoretical disagreements, I wouldn't go on this issue because I think it's well known by all people who are here, is different from empirical disagreements in a sense that what is at stake whenever people have a theoretical disagreement is the very concept of law, a conception of the concept of law. And this doesn't, this is not restricted to a difference in a theoretical perspective, but it's also connected with how we can reach, how we can understand and respond to the theoretical challenge towards explaining what the law is. So, just to say in other words, it's a dispute about the grounds of law. It's not only a dispute about how we can make a theory about law, but it's also a dispute about how this theory should be made. So it's about grounds of law. It's encompass many other dimensions, methodological and epistemological dimensions, that is not really reduced to theoretical differences of the same kind. Because sometimes we have disagreements about the very kind of theory that should be made in order to explain what the law is. Now, Dworkin shows the relevance of this kind of disputes in many famous examples. For example, the Tennessee Valley Dam construction, Tennessee Valley Authority versus Hill, in which Chief Justice Berger dissented with Chief Justice Powell, and in which this kind of theoretical disagreement was at play. And why is that? Because both admitted their obligation to follow the law, however, and they both accepted the basic empirical aspects that were set in that case. However, they had a very deep disagreement about what the law is and what and how we should understand and how we should, what are the methods through which we can understand the very concept of law. There are many other similar cases which I discuss in my paper, but it's not necessary to go on all of them. In my paper I also discuss the model of chess as being a kind of canonical way by which we can understand how the law is structured. We can understand, for example, in a game of chess, the proposition that, for example, in chess we can't move the horse in diagonal, and we can offer a quite convincing explanation of why is that forbidden, which is that there is a convention that constitutes the chess as a game and which fixes the rules that doesn't allow such a move on diagonal. However, whenever we think about law, it's very misleading to compare it directly with the structure of chess, as many authors, like, for example, Andrei Marmor has a paper on this. And why is that? Because, well, because there's an evaluative dimension whenever we think about law. However, the very moral or evaluative dimension of law could also be thought in terms of conventional explanation. For example, we can think about a standard of correctness that is based, that is also grounded in social conventions. However, I think that there's a very important point made by Dworkin, and in the paper I discuss what could be an imagined like a hypothesis of a kind of argumentative chess, a chess in which the players and the supporters of two players could support the idea that the rules of the chess should be changed in order to provide some kind of equality of chances for two players to win the game. Let's say that a toddler is playing chess with a teenager, and generally when this kind of game happens, it's quite common to give some kind of advantage for the toddler in order to reach some kind of equilibrium. So this kind of argumentative and reflective kind of chess is usually based on some idea of fairness, which is depends on some kind of equilibrium and the arguments that can be made during the game that would justify that the game, this kind of game, is still fair, is still based on non-excessive, non-abusive rules. Well, in this kind of argumentative chess, of course, we could still think about some conventionalist explanation about how the conventions are being transformed, are being changed during the practice of the game. However, I think whenever we give this kind of explanation for such a game and many others that we can think about, we are missing a very important distinction that Dworkin has made in many works and through many strategies, which is the distinction between what he calls the conventional morality and the concurrent morality. A concurrent morality is that morality that requires the players and those who are focused on interpreting the meaning of a value to this process of interpretation. An interpretation that is not reducible to the actual meaning that is shared by some kind of community. And I think that these are very, just to just to finish, I think that this issue and this distinction is very important, and maybe for many people it's very trivial as well. However, whenever we think and follow the debate that was created about conventionalism and the replies, it's amazing how, under my view at least, many of these very basic distinctions are put aside, are not taken seriously. So in many ways, Dworkin's challenge is not being, has not been responded in the way I think he could be. He might be wrong, but he's not wrong for many of the reasons that are offered by these conventionalist theoretical enemies. So, just to sum up, I would say that what I intended to show is how, in this paper, is how legal conventionalism presents itself as an important strand of contemporary legal thought. Its relevance is given both by its explanatory potential as in the consequences it brings to legal practices, not only for lawyers fond of philosophy, but for all of them, as they share many of the conventionalism presuppositions, even when they don't have consciousness of that. In my view, the Dworkinian challenge towards conventionalism has not been convincingly matched by conventionalist answers offered to it. Of course, a more in-depth analysis is required in order to justify this conclusion. Some sophisticated versions of legal conventionalism try to respond to Dworkin's challenge. Andre Marmor, Jules Coleman, Scott Shapiro, among others, spend a lot of energy and intellectual skills to cope with these difficult theoretical issues. My intent here was only to offer a brief and sketchy overview of main questions and methodological challenges that should be faced by those who try to decide to reply to Dworkin's critiques. Despite of their possible success, it's clear that the challenge posed by this great author imposed a new agenda to contemporary legal debate. The greatness of an author is not exclusively measured by the correctness of her ideas about problems, but also by her capacity to help us to realize the existence of new questions and problems. And I think Dworkin's impact in contemporary legal theory is exemplary of both. Thank you.
Thank you very much, Professor Porto Macedo. And now, Professor de Lima Lopez.
Thank you very much. Is this working? Yeah. Thank you very much. First thing is to thank Marcelo Alegre and the University of Buenos Aires for inviting me here and having the opportunity to share some ideas, not on Dworkin's work directly, but some ideas on interpretation, and mostly from a historical point of view. That's the sort of thing that puzzles me today. And also of meeting some good old friends after some years of distance and not meeting them. Thank you very much. So, I have a point in my paper which is not an answer, but a question, actually. And I'll put it briefly in the beginning, and then I'll go through the paragraphs on the paper. It's still a work in progress, so there are lots of things out of place here. But the idea is the following. There was a time when lawyers thought that interpretation was not necessary. Of course, in history, they would call interpretation a very strict practice, and then not everybody was allowed to interpret. The idea was that law was and had to be certain. So I begin my paper with the Latin phrase that I got from a humanist lawyer, Duarenus, and the phrase in Latin is certis juris nulla interpretatio desideratur, nisi apud impeditus. And I use that phrase with my students very frequently. Of course, in Portuguese and in English, it would be, what is certain, what is clear in law does not need any interpretation. And then he says, except for the inexpert. For the ignorant, he says, for the ignorant, everything is uncertain. But those who know law don't need interpretation all the time. That puzzled me. Certainly he was talking of interpretation in a different way compared to what we think interpretation is. Where we as lawyers, I'm not talking about Dworkin exactly, but we as lawyers tend to think of interpretation as always necessary. So I begin the paper with this very short description of what happened between Duarenos, the 16th and the early 17th century, and us, that made us, as lawyers, believe that we are always interpreting. Of course, there are institutional changes and political changes. There's a change in the relation between legal scholars and law. In the time of Duarenos, legal scholars made the law by means of their doctrine. So if you wanted to know the law, you had to read the doctrine that lawyers, law professors would publish and write. This has changed a lot. But what I think has changed is actually the very idea of interpretation. We take interpretation to be one thing, and previously lawyers didn't think interpretation was that. And I think they made a division, a separation, a difference between grasping an idea, having a concept, and interpreting. And I believe that this is part of the debate that happened in philosophy in the 20th century. So the idea is grasping a concept, apprehending a concept, an idea, is not an interpretation. That's having an idea. And then interpreting is doing an empirical, let's say, if it's not empirical, but a real or definite or contingent historical application of that idea. And in those cases, you may have the idea, but there are cases in which the case is not clear for you. That's when you need interpretation. I think this is the difference of earlier legal scholarship and 19th century legal scholarship. And of course, the division happens with the work of the most paradigmatic example is the work of Savigny. Savigny says every statute needs interpretation. And this is, in this, which was a minority position in the early 18th century, becomes the majority position by the end of 19th century. So everybody believes that every statute needs interpretation. And Savigny said that exactly, but there was a long discussion during the 19th century about this. Do we really have to interpret everything, or are there things that are clear? So my idea in the paper, I'm not really following everything in the paper, but my idea is, when we look at the analytical philosophical tradition, we are going to find in Wittgenstein and his followers and people who discuss his ideas, this division between grasping an idea and interpreting. I think that's the point in Philosophical Investigations, paragraph 201, when he says, we should restrict the use of interpretation to translation. Interpreting is saying the same thing differently. And this, he says, is not the same thing as having an idea, of grasping a concept, of getting a notion of something. I think this is important because I think a lot of discussions we're going to have in the 20th century and still in this first decade of the 21st century is this. We have maybe to decide that grasping a concept of law, having a concept of law is one thing, and we may have discussions in clarifying the concept, but that is not interpretation. In that sense, maybe I could be critical of Dworkin, but I don't think I am that critical of Dworkin. Talking a lot with my friend Ronaldo, he says, you think like Dworkin does. you don't really disagree. But I think this idea is very important, that having an idea and interpreting, using that idea in particular cases are different things, maybe different things, and in particular cases, then you may have some doubts. And in the, let's say, historical tradition of Western law, people would explain, why do you have doubts? is this doubt, is this plausible? And then they would say, yes, it's plausible because the language of the law is not really clear, or there are some problems in the text, or the case itself is new. The case itself does not respond to the ordinary idea we have of that case. So if you have new cases, you're probably going to have to interpret. And this is very typical of our practice as lawyers. So this is one of the things I think that connects our discussion in law today with some philosophical discussions in philosophy itself. So we could say that analytical philosophy, or the philosophy of the later Wittgenstein, would help us understand what we as lawyers are doing. And the second tradition, I think, in the 20th century that help us, again, make this distinction between interpreting and having an idea, a concept, comes from the hermeneutic philosophy. Even though these two traditions, analytical philosophy and hermeneutic philosophy, are always treated as, let's say, intellectual enemies or adversaries, in fact, when you look at the hermeneutic tradition, you find something very interesting, which is the idea of the background. Interpretation always depends on a certain background, and this background has to be shared. Otherwise, no dialogue is possible. So you have to share something, in my view. You have to have an idea which is fairly common among people who are interpreting in order to really advance in interpretation. So this idea of background is, to my mind, a sort of functional equivalent of the idea of grasping a concept in Wittgenstein. So both of these trends in philosophy show us that maybe as lawyers we should rethink the idea of interpretation, in the sense that we may have doubts, but we do have, in fact, something in common. Otherwise, these doubts would not be either disputable or solvable in any way. And I think this has a little bit to do with Dworkin's idea of not foundationalism, but the idea that we have to have something in common to discuss, or if this concept that's not common, this idea of law that's not common, we have to make it common. We have to discuss. We have to deepen the discussion about that. So basically, the paper is about this. It's a historical perspective on the debates on interpretation. And I believe, going back to the beginning of the paper, that institutional changes and changes we have been facing historically are part of what put again the agenda of interpretation in legal theory. In the 19th century, they had to deal with the idea of codes, of a national legislator, and of the sources of law being strictly law, statutes in our tradition. And legal scholarship would be a parasitic activity compared to the production of the law by the legislator. I think this is what is changing today. I would say that in the second half of the 20th century, the growth of constitutional adjudication in courts made a very important change in the institutional setting in which we are dealing with the law. We are treating constitutional law as part of the law, and a lot of our theory of interpretation was developed in private law, not in constitutional law. And I have two examples here in the text. At least in the continental tradition, the codes, our statutes, would give judges a sense of what interpreting is and the methods they could use to interpret the law. And I use two examples. One is from the Austrian Civil Code of 1811. And the Austrian Civil Code said this, said, the judge, in interpreting the law, should use, of course, first thing is the statute itself, the law. If the case is not sufficiently provided for in the statute, in the code, then he should use analogy. He should use what is similar. If the case is still unclear, he should decide with all due care concerning the particular circumstances of the case according to the fundamental principles of natural law. And then, of course, there is this background of natural law that most people shared that would make the case plausibly decided by natural law principles. And then, he says finally, if the judge, even with the help of natural law, still finds the case difficult, he should refer the case to the legislator, who would then decide it finally. A very interesting thing happens in the end of the 19th century, which is the, I think it's Article 7, it's here in the paper, of the Swiss Civil Code. The Swiss Civil Code has been was enforced in 1907. And there, the instruction to the judge is, well, the judge will have to decide the case. He will use the help of the principles of law. And then if he doesn't find a solution, it's very interesting, the code says, then he should decide the case as if he were the legislator. So he would use the principles a legislator would use in providing for that case. Of course, the idea that the decision has to be universal and has to use a Dworkin expression, fit the entire code or fit the entire system. So basically, this is what I show in the paper, I talk about in the paper. Do we have something as lawyers to learn from these two traditions? I think we do, and I think both traditions, what they do most interesting for us lawyers is show that grasping, having a background assumption, is different from interpreting the case. And then, if this grasping or this background assumption is what is at stake, what we are doing is, of course, interpreting in a very general sense, but not interpreting as Savigny would put it, which is equalizing everything we do in the law. This is, as I said, a work in progress. That's what I'm trying to investigate, and from a historical point of view, I want to go further into the 19th century and 18th century scholars, legal scholars, who are talking about interpretation. That's the idea. Thank you very much.
Yes, thank you very much, Professor de Lima Lopez and Professor Kornhauser.
So I want to do four things, I think, in this brief discussion. I want to identify what it is we can do without. So the title says doing without the concept of law, but I actually think their concept is used or needed to answer various questions, and I only want to do without it for some of those questions and not for others. Second, I want to explain briefly what it means to do without it. And third, I want to sketch why I think we can eliminate the concept of law, or the one I want to get rid of. And then I want to explain why Ronnie really was really saying what I'm saying, okay? Which, if he were here, he would deny vigorously. But I get to win this argument by default with him in any case. So what is the concept we can do without? I think there are basically four different questions floating around that often get conflated, or some maybe put differently, that some people think we need the same concept to resolve. So both Hart and Dworkin, in some sense, recognize this. Hart often said in the postscript that He didn't quite understand what the Hart-Dworkin debate was about because they were asking different questions. Hart's question, and Dworkin similarly says, I think it's in Justice in Robes, he identifies 4 different concepts of law and then picks the one that he's interested in, which he calls the doctrinal concept of law, and then frames the debate between Hart and himself in terms of that concept. Okay, so the 4 concepts that Dworkin identifies, he calls a sociological one. I would prefer to call it a social scientific one, probably because I'm an economist, not a sociologist. Taxonomic concept, a doctrinal concept, and an aspirational, or what I'll call an evaluative concept of law. So Hart is, I think, interested arguably in the taxonomic concept and possibly in the sociological one. He wants, in the concept of law, to distinguish legal phenomena from moral phenomena and coercive phenomena. He wants, and arguably he wants to be able to pick out the legal institutions of different countries in order, in some sense, to conduct comparative law, right? If you're doing comparative law, you have to know what it is you're comparing. You have to identify comparable institutions. So that's Hart's project, or it's a project about social scientific project about trying to understand social groups, how they organize themselves, how they develop, how they control people within it. So that's what Hart, I think those 2 questions are questions that are central to Hart's project, at least as he formulates it in the early pages of the concept of law. But his answer actually does provide an answer to the question that Dworkin wants to ask, which is the doctrinal concept, which he says is the question of what makes a proposition of law true. So on Dworkin's account, they're propositions of law, right? Judges have to decide cases. People need advice on whether what they're doing is going to be, quote, contrary to law or not, right? These are propositions of law, right? And they're, in some sense, internal to the operations of a governance practice, to a legal practice. And that's the concept I want to do without. Okay? So I want to eliminate this doctrinal concept of law, and I'm going to be sort of agnostic as to its whether we need to eliminate the prior 2, the taxonomic and the social scientific one. I actually think it's not obvious that social scientists need a concept of law to explain things, although that's a somewhat complicated statement. And I want to preserve certainly the evaluative concept of law, which I want to understand as something about what the value of legality is. Okay, so I think that's actually important. I think, in fact, that one of Dworkin's important contributions to the philosophy of law was to offer us an account of what the value of legality was. He called it integrity, and it's that value that we should be trying to elaborate. Okay, so that's what we're doing without. I want to do without the doctrinal concept. So what does it mean to do without? So I might be making any of 3 different arguments, and as the paper currently stands, it's a little hard to tell which of the 3 I'm making. Okay? And I'm not going to be much clearer here today, unfortunately. So the first is a very weak form of doing without. It's just the fact that I can essentially reframe or restate everything we would want to know. Every time someone wants to use the concept of law, I can just reformulate the question or the answer without reference to the concept of law. So it's very minimal. The second form is much stronger, and it sort of says that we would do better by doing without. So it's not just that I can restate everything without reference to the concept of law. We in some sense do better by not referring to the concept of law. And I think this is, I want to do without actually in that stronger sense. And the reasons are going to be parallel to arguments that say, I'd say in some sense that Liam Murphy, Stephen Perry, and Dworkin himself sometimes made, that they wanted to say the nature of the concept of law was it's a political concept, and the question was, is it better to incorporate the ideas of morality within the concept of law or to keep them separate? So the positivist position is we do better by separating the evaluative judgments from the judgments of legality. That is, we do better in some sense of how well we govern ourselves or how well social life goes by making this distinction, right, by keeping these two ideas separate. And so I'm, in some sense, my position is arguably a hyper-positivist one, right, that it really, really is important to keep these ideas separate, and it will make our social life go better. The third form, and the strongest form of the argument, is one that there's just no concept for us to have. So it's not that we're not doing without anything. There's nothing there to do with, there's nothing there. There's no there, as Gertrude Stein said of Oakland. Okay, so what I want to do without for purposes, today's purposes, is either the weak form or what I call the semi-strong form. That is either just this minimal claim that we're doing without, I can reformulate, or this somewhat stronger claim that we do better by doing without, that this reformulation helps us in terms of providing good governance. So, okay, so now I need to explain why I think we can do without. So I want to give you the case for eliminativism, as Liam dubbed this position. So the case is, in some sense, is very simple. I want to distinguish, I think social scientists need a concept of governance, right? They need some way of describing the organizational forms or the way in which social groups manage themselves. And governance in modern municipal legal systems, as Hart describes them, is actually extremely complex and exhibits a vast amount of division of labor. So that some legislatures and administrative agencies creates law in some sense. Executives execute them. Courts adjudicate them, and then we have separate institutions actually that enforce them, right, once the court has identified a violation of a relevant norm, right? So in a simple civil case, after the court rules, if someone fails to abide by the judgment of the court, the sheriff enforces in common law jurisdiction. So they're separate institutions, and each member with person acting within this institution, as well as private citizens, sort of bear very distinctive relations to what I want to call the legal materials, the outputs of these institutions, the legislation, the regulations, and the opinions of these institutions. And that each of these people, when deciding what to act, how to act, or what to do, it's not, they have to refer to these materials, but they also have other sets of considerations to which they need to refer, right? So they have considerations of sort of institutional considerations of what their competency is, what they're capable of doing, and as Dworkin would argue, they might have moral obligations or moral reasons for doing one thing or another. Okay, now so we might say, going back to Dworkin and Dworkin's account, so sometimes Dworkin was accused of not having a theory of law, but having a theory of adjudication. I actually think that Justice for Hedgehog essentially admits that, because he says law is really the thing that happens in courts. It's not happening in legislatures, and it's not happening in the executive, right? It's only, legal rights are only those rights which are enforceable in court. And his account of of what the judge should do is well, let me step back. So the positivist says, the positivist account is for each of these each of these public officials is first determine what the law requires, and then consider all the other reasons you might have for doing what the law requires. And sometimes those reasons will outweigh the legal reason, right? And sometimes they won't. When they outweigh the legal reason, you should do what all things considered, actually in each case, you should do what you should do all things considered for the public officials. And sometimes that comports with the law and sometimes not. Ronnie's theory of adjudication just turns that in some sense into a one-step process. You don't, on my account, really have to figure out what the law is. You just need to think about all the reasons you have for resolving the case one way or the other, and then do what you should do, all things considered. There's no reason or need for the judge, or for that matter, I say, any other public official, to segregate out a set of particular subset of these considerations and identify them as creating a legal obligation to do something or not to do something. So you can see that characterization of what eliminativism is doing sort of indicates why I think Ronnie really holds the position that I hold, or maybe I should go the other way, that I hold Ronnie's position. Because in essence, he's already he's created a theory of adjudication, a theory of what judges should do, all things considered, that in some sense drops out the idea of law as an independent set of reasons and segregates it from the actions or the decision-making processes of other public officials, right? So he too needs a theory of how legislators should think about what they should do, how administrators, commissioners and administrative agencies, about how they should go about doing their jobs, how the police on the street should go about doing their jobs, right? These are all people who in some sense are also have to pay attention to the legal materials, that are going to have their actions coordinated by these legal materials, but they're also people who have distinctive institutional settings with distinctive institutional reasons for understanding these materials in different ways. So maybe I will just stop there.
Thank you very much. I don't know if you have some questions to make you to each other, or no? Yes? Okay. I have some questions for you, but in order to clarify your points, for you, Ronaldo,
Yes.
On page 14th, you say that when there are theoretical disagreements, what is being discussed in them is the very concept of law that should serve as the truth condition for the legal proposition. But I could say that not only that, according to your reconstruction, what is at stake is the place that legal norms play in practical reasoning. I don't know if this is the idea that is implied there in your paper. And maybe you can then clarify me this. And for Jose, for Professor Lima Lopez, I would like. I didn't really. I don't understand really your criticism to Dworkin, because don't you think that in this idea of grasping or background assumptions that you refer to in your paper is the idea of pre-interpretative stage that Dworkin recognizes? I don't know. Maybe I would like, and if not, I would like to know which is the difference that you want to point to. And for you, Luis, yes. You talk on your paper of legal materials, and it is not clear to me in what sense we can identify those legal materials without having a doctrinal concept of law. Your idea of doctrinal concept of law was not very clear to me, and another question is in what sense all the distinct decision-making protocols do not presuppose several doctrinal concepts of law, or are not presupposing several doctrinal concepts of law. It seems that your problem is not with the idea of a doctrinal concept of law, but with one doctrinal concept of law, the one that presupposes that legal norms have a special place to play in legal reasoning, in practical reasoning in general. So these are my questions for you. I don't know if you can clarify a little.
Okay.
Should I start?
Yes, please.
Okay. Well, before starting, just let me add something to Lewis that called my attention when I was reading your paper before I answer my own question, which is as far as I understood your point, Lewis, it seems that you are. I had the impression that you were taking these different kinds of concepts as being completely different in terms of their nature. Of course, Dworkin many times uses the idea of kinds of concepts and the doctrinal concept or interpretive concept as, for example, a type of concept. However, I think that there are many passages in which it's clear for me to understand that we cannot really say that one concept is of one kind, like for example marriage. Is marriage a sociological or criteria concept or interpretive concept, or is concept of law a sociological, doctrinal concept? But basically is the fact that whenever you use in a different context of use, even though you want to keep your attachment with the way you define the concept as criteria or sociological, whenever you move to a different setting, you start using it in a different way. It gets this new kind of meaning. just to be more accurate. For example, when you talk about is marriage a criterial concept? Well, it can be, of course. It can be. Anthropologists can analyze what marriage is considered in a primitive society, or historians could discuss what is the meaning of marriage in a particular context. However, once you invoke the very concept of marriage, for example, in a Supreme Court that has to decide whether same-sex marriage is allowed, so whenever, even if you invoke a criterial concept of marriage, or even if you invoke a sociological concept of marriage in order to support your claim, you would be now using it in an interpretive way. So you would be now using it in a doctrinal way. So it's not an issue concerning different really kinds of concepts, but different ways or different functions. The concepts could function in an interpretive or criteria way as much as the very concept of law could function as doctrinal or sociological. And sometimes a sociological definition is used to serve the purpose of a doctrinal concept. So that's my point. Well, let me come back to my question, which is, well, what I try to say here is that the place of legal norms in practice, it's of course important, but whenever we think about what is the meaning of a legal norm, that very question brings together the concept of what is being a legal norm, what is to be considered a juridical norm, and not only a valid norm. What is at stake here is, anyway, what should be considered the source of law. I think that according to legal positivism, the only issue at stake is the issue concerning the validity of norm. And that's one of the reasons why I think that, for example, Dworkin in his article on Heart that was published in Justice in Robes, he criticized the very concept of legal validity as being misleading, in the sense that it brings together a theory of how to conceptualize what is legal, what is juridical, that is already contaminated with some mistaken presuppositions. So to answer your question of the place of legal norms, okay, but the very issue is what is to be considered legal and legal norms, and whether, for example, those moral considerations or moral reasons are constitutive as well of the very meaning of a legal norm. So I think that's how things are brought together.
Thank you for your question, Paula. I would say that I was not really trying to criticize Dworkin in this. I'm possibly more interested in the way Dworkin's theory is being used in Brazil. That's probably the setting of my paper. And there, people are using it in a sense saying that everything is interpretation, so they are giving a skeptical, let's say, application of Dworkin, which I think is quite contrary to what actually he was saying. So that's the setting of my paper and my questions. So what I'm trying to say is that this grasping of the idea, which is probably the pre-interpretative stage, is a necessary background for any sort of discussion. Now, of course, the idea that we grasp in a practice is subject to change, because the practice is being changed all the time. So we practice, and we change the practice as we are doing it, performing that inside the practice, we change the practice. But that's basically the idea. So I'm not criticizing directly his point. I'm going back to this tradition. Is there anything certain in law? And for people before, lawyers before our generations, they say, yes, there is something certain. Of course, you can clarify it and you can discuss it, but there is something certain. Or otherwise, we wouldn't be doing the same thing. We wouldn't be doing, for instance, as members of a court or even legislators, we wouldn't be in a institutional framework. We have to share this institutional framework, and this institutional framework depends on sense. You got to have the sense. Of course, the sense is it doesn't grow on trees. So we have to be conscious of that sense. And being conscious, we are being reflective. We are, in a way, in a broad sense, interpreting. That's what we're doing. We have to share some sense. Otherwise, we wouldn't be doing something together. Of course, problems in societies which are multicultural or going through very divisive issues, then it's very clear that this sense may be the issue, maybe is what is at stake. But that's just what I was trying to say. You got to share some sense. And even in political divided societies, there is some sense you got to share.
I would like to also make a very brief comment on Louis' presentation. I want to make a comment on Louis' presentation. There are two levels of analysis, the descriptive and the normative, that I want to touch on. As a descriptive enterprise, I'm not sure if Louis is eliminating the concept of law or is reformulating the concept of law, describing law using different words, for example, governance structure. So it's not very clear for me the usefulness of this move. There are several situations where it's not clear what's the force of certain arguments when a judge has to make a decision. For example, our Supreme Court has said that decisions by the US Supreme Court should be taken as binding because our constitutions are very similar, so the interpretations of the American Constitution by the US Supreme Court should be taken into account very, very strongly when we interpret our constitutional clauses. And there, a concept of law presumably is useful to distinguish the fact that maybe it's a good idea to take into account the opinions of the American Supreme Court, but that's not a legal obligation. That's not part of our law. I don't think how can we do without that concept of law to resolve those cases. Another case, for example, in human rights law, usually some documents, opinions of international committees, committees of regional bodies are taken as binding by human rights lawyer. And there is the argument that maybe these are very clever and wise opinions and reports and so on, but they are not part of the law. And that makes a difference. It makes the difference between a binding opinion or argument or reason and one that it's not binding for the judge. From the normative perspective, I would like to ask Louis if what's the normative performance of this elimination, the result, the impact? Is it that we should embrace pragmatism, this idea that the judge should make all things considered without distinguishing the origin of the arguments or the reasonings? Because if not, if there is no impact on the normative side, if Hercules could do without the concept of law and still resolve the cases as Dworkin would have suggested, then also it's not clear for me the usefulness of eliminating the concept of law.
All right, so I'm going to take the questions in the order they were asked, and I'm going to try to be brief. Apparently I need to be not only brief but loud. So Paula asked first, how do we identify legal materials? So I think there's, so first, I mean, when I say legal materials, I really just mean the texts that various institutions produce, right? So as opposed to legal materials in the sense of what the legal obligations, rights and obligations that people have given these texts. So, so the question might be, how do I know which texts in the society are the relevant texts? Well, so part of it is, and this is going to turn bear on Marcelo's question as well, is so I do require an idea of a governance structure. So people have to be able to identify central elements or central features of their society that tell them, basically identify things like rules of change, some sense rules of recognition, those types of things, right, that are going to pick out particular institutions. But I want to, as I said before, I really want to drain them of all moral content. So again, in part in reference to Marcelo's question, this is, so from governance structures, criminal organizations have governance structures, as do states. And I would say many states actually look a lot like criminal organizations. And I'm going to refrain from naming names. And I think those, whether those collectivities have law or not, seems to me an evaluative question. That is, when we say that this collectivity has law, it's a term of commendation. We're patting them on the back for getting something right. Exactly what they're doing, what they've gotten right, the evaluative judgment we're making, I think is often unclear. That's where I think the evaluative concept of law should come in to tell us when it's appropriate to pat people on the back, or collectivities, when to pat them on the back. But these other collectivities are also, they're organized, they're functioning, they're often controlling territory, right? They're doing all sorts of things. They're governing, and I think we ought to be able to talk about them without invoking any of these commendatory ideas, okay? So that's the motivation. So I don't think it looks like law. Even Hart, in the concept of law, talks about the minimal moral content of law, right? So even the positivists have this commendatory term view in it, and and for instance, Jules Coleman uses it in the precise terms of commendation in his essay in one of those Oxford handbooks. So I'm, as I said in my remarks, I'm in some sense really a hyper-positivist, right? Let's just drain everything drain all the moral content out of these ideas. So your second question concerned whether there are multiple, instead of eliminating the concept of law, I've multiplied them. Right, so this is going to go in part to Ronaldo's question, my answer. It's going to go in part. So we have, in some sense, a terminological problem. I certainly have it in this paper. It's true, I am going to produce multiple theories of decision-making, right? Some for public officials, and some for citizens, and some for lawyers, right? They may face they face somewhat different decision problems, and therefore they may require different decision protocols. Okay, now, I don't want to, should I call those law or not? I don't know, that's sort of just a semantic issue in a certain way, which brings me in part to Ronaldo's question, which I hope to tie back in to this. So when I said there are different concepts of law, I introduced that idea by saying there are different questions that we're trying to answer. Right? So I think it's a very different question to ask. How do we evaluate social institutions, which is, in essence, the evaluative question? What's the appropriate set of criteria against which we should assess these institutions? And some of them look legal, right? So in some sense, that was Lon Fuller's approach to thinking about law. He said, law are those sets of institutions which comport with these 8 criteria, which produce norms that comport with these 8 criteria. And that's valuable, right? Because those 8 criteria are valuable in a particular way. Okay, so I started with questions and not with concepts. The concepts, from the social science point of view, the concepts are going, and I actually think from the doctrinal point of view, the concepts we have are technical concepts. They're not ordinary language concepts. I don't think, which is what's confusing the discussion. So there is an ordinary concept of marriage, right? There's something that we talk about when among us, sort of a folk idea of marriage. And the question is, and then there's a doctrinal concept of marriage, right? Which is, how does the law characterize or define what gets treated in particular ways? And that concept is easily conflated with the folk concept, because the folk concept and the technical doctrinal concept we're using the same word to identify them. And similarly, for the social scientific concept, in some sense, social science, right, if it needs a concept of law, it's going to be a concept that's designed to answer the questions that social scientists are interested in asking. And it would be amazing to me if the social science concept happened to correspond to the folk concept of law that people had, just as it would be amazing if the concepts of physics that physicists use to explain the natural world were to correspond to folk physical concepts. There's going to be, folk physical concepts have adjusted to some extent to the technical concepts of the physicists, but they still don't mesh in the right way. So I'm not talking about different kinds of concepts in the sense you were asking me about. I'm not shifting between criterial and interpretive concepts. I'm interested in the sets of questions that we want these conceptual frameworks to address an answer. And I just think the demands, the questions that these frameworks are asking are different. And so they're going to require different conceptual structures to respond to them. All right. So let me turn to Marcelo. So Marcelo's question, so my first weak sense of eliminativism is not actually that far from what you're accusing me of. So I guess I have to say, yes, if all I'm arguing for is that weak version, it's not a big deal. I'm just reformulating things, although you're saying that more than I've just reformulated, I've transferred the idea of law to this idea of governance structure. And as I said to Paula, I don't think that's true. The idea of governance is much more general than the idea of law, or at least as commonly used in the concept of law debate. So it may be that legal systems are a subset of governance structures, but they don't encompass it. And let me say something similar about your last point about the normative thing. Right, in some, because I think Ronnie's, the late Dworkin's position, late I mean in terms of justice for hedgehogs as opposed to, say, law's empire. Right. I think Dworkin's position in justice for hedgehogs is very much an eliminativist position in the sense, so it's not going to change much because he's really doing the same thing. He's just saying, look, what judges ought to do is make an all things considered judgment about whether plaintiff should prevail or not in this particular case. And I'm going to produce, my story is going to produce the theory of adjudication, which does exactly the same thing. Okay? So the middle question, the question about the idea of sort of binding versus persuasive materials, which is how I interpreted your example about the Supreme Court here and the international human rights thing. So I think that in my account, those differences are going to be reflected in the different ways in which institutions may be situated with respect to one another. So in a simpler example, in some sense, right, in the United States, there are circuit courts of appeals, and there's horizontal stare decisis within a circuit, but not across circuits. Right? So that's, in some sense, not sure. That's people think that that's the appropriate way to respond to organize the adjudicatory body across a vast geographical area. There are advantages to doing it that way. The system has accepted that doing it this way, the advantages outweigh the costs, and they're going to just behave in that particular fashion. Okay, so I'm going to stop. I've already talked too long. Thank you. Oh, I'm sorry.
So thank you very much, all of you. Now we can open the discussion. Carlos?
So I am Richard Stewart from NYU. It's a pleasure to be here at this conference on Ronnie and his work and his influence here. I have a question for Louis. I'm very sympathetic to your overall enterprise, but I wonder whether you need to or even can jettison the idea of legal obligation. I noticed in response to Paula's question, you said, well, we turn to texts, or citizens can turn to texts to find out their legal rights and obligations. So that's your locution. So let me, this complex governance structure generates many different kinds of norms. But we do, in our discourse and practice, regard certain of these norms as having the quality of being legal and binding. Officials have that, and citizens. And let me just give you an example, since I'm an administrative lawyer. Administrative agencies generate different types of norms. Let's say, as an example, one, regulations that we call substantive regulations that have the force of law, that citizens are obliged to obey, and if they violate them, there are certain consequences. They may also issue guidance, which is the agency's view of how a regulatory scheme should be interpreted, its sort of direction to staff, and the citizen might disagree with that. It's not bound, we would say, but might have good prudential reasons to go along and not have a project it wants to get approved to be turned down. So, in your system, how do you differentiate these two norms? One could differentiate it depending on, how the process by which they're generated. The regulation has to go through certain procedures, how courts or other officials might regard it. But what about the citizen who differentiates binding norms and norms that are not binding? I don't think that can be reduced simply to the consequences of not conforming to the norm. And if you say, well, it's just different consequences that are all things considered judgment about what the citizen should do, don't you diminish the moral agency of the citizen?
So if I said what you said, if you said what I said, then I somewhat misspoke. So citizens, like everybody else, look to these texts and to their situation relative to various institutions. And then they require some story about some theory, either a normative theory about how they should process these different materials, along with whatever other concerns they might have. Okay, so that's saying everything without saying they have a legal obligation. Okay. So I like your distinction between your example, the difference between a substantive regulation and a guidance document. I think those are two very different types of documents. They have different things on top of them, right? And they're meant to be treated differently by the citizens and by other administrators as well. So in one, in the substantive regulation, the agency is trying to commit itself to behaving in a particular way. And with the guidance document, they're saying, we're not committed to doing this, right? So you should take this with arguably a grain of salt, or as having more play in it than the other, than a text which has the different heading. So in that sense, I think the citizen, right, they're supposed to pay attention to what these texts say. These texts are communicating something. They're giving signals about what's going to happen in response to various types of behaviors on the part of the agent. And they should understand that when they're making their decision. Their decision-making protocol should quite reasonably take those things under consideration or into consideration. Now, as an aside, yes, I'm an economist, so after all, I have strong tendencies to want to be consequentialist all the way down, but I'm not sure that the story I'm putting out here requires that. But it may. I mean, I may be pushed to that by the end of the hour.
This is a question for Luis. I'm also sympathetic to your project, but I want to clarify what your project is first. Because are you just saying that the practical question, meaning what an agent should do in given circumstances, dominates the conceptual question, meaning what the law is? Or you're saying something more than that? You're saying that, and in addition to that, that the agent shouldn't give any special consideration to a subset of facts. For instance, people gather in a building we call a parliament or Congress, raising their hands in certain circumstances. If you just say the first, that the practical question dominates, and to some extent the concept of law, it's entirely practical, it's dominated by what we should do, I agree. And I think Dworkin, that was Dworkin idea in my view. But if you say the second, you're like a reductivist, in the sense that you're ignoring different dimensions of normativity. Your last question, your last answer seemed to move you to the second kind of response, in the sense, if you're really consequentialist, if everything you care about is just consequence, normativity shouldn't have any room in our practical reasoning. But again, I think there are two very different kind of eliminativists. I wonder which one are you, which one is yours? The first or the second?
So it may depend on what I ate for breakfast. So it's certainly the case that I'm the first, right? That's, and again, the weak form. I think I am, I want to argue for something that in the paper I call the semi-strong form, which isn't quite what you're characterizing. So I think the weak form is something that can easily, so there's nothing that requires me to say there isn't any special significance to the fact that it was the 435 bozos in Washington, D.C. who raised their hand in a particular pattern that yielded this particular text, right? To saying then that should be treated differently than, you know, the text that was produced by me and my 99 colleagues at NYU, right, on a similar subject, right? So I think that's easily captured in some ideas about, not without reference to necessarily ideas of normativity, right? As you know, I have difficulty understanding normativity, and certainly your position on normativity. So I think I can, right, I can talk about those things. I can think that they can provide me with different types of reasons, different types of considerations. That is what my faculty said and what the Congress said in terms of making a decision, a particular practical decision. Now, even consequentialists need some normativity, right? So utilitarians need to think that what they ought to do is do the thing that maximizes welfare, right? So at some point I'm going to, if I'm going to make some recommendation, I too am going to rest on some obligation, right? It's just where in the process that obligation comes in, right? I don't think it's helpful, right? This is the way in which Ronnie's, I want to use Ronnie as a proto-eliminativist. It isn't helpful to segregate out what the legal materials say from what it is that the judge should do, all things considered. And I want to say that's true for everyone, right? And it's true, so, and maybe I should have said this in response to someone else. I think it's useful to think of under-enforcement as another articulation of the eliminativist view. Ronnie thinks there is no under-enforcement of legal norms. That's because it's only judges who implement legal norms, right? What Congress is doing when it expands the scope of Section 5 of the 14th Amendment under, right, is not law. It's not law until there's some adjudication. That strikes me as a very odd position in some sense, but it's a position because he's narrowed law to adjudication. I just think he's reflecting the fact that what legislators can do and what judges can do, given the set of legal materials that we have and the institutional arrangements we have, are just different. Right? And it permits Congress to do things, to produce texts which push enforcement beyond what the court would be permitted to do or think they should do in their absence.
I have a brief question for Professor Kornhauser. In your paper, you talk more about a theory of adjudication than about a theory of law. So I wonder, could we describe your tenet as American legal realism rises again, also in a new version?
Well, it might depend on what we mean by legal realism. So I'm not offering something that looks like Hart's account of legal realism, which is Score's discretion. So I'm not offering that. Because normatively we might think that what judges ought to do, right? There's something that they ought to do, which is a standard distinctive from what they actually do. And that would be true for each of the theories of decision that I'd be offering for each of these positions. So in that sense, so it's not legal realism in Hart's sense. Whether we might have an account of legal realism which had some external story like I'm offering about what they ought to do, which I think in fact is probably what someone like Llewellyn believed. He didn't think they could do whatever they wanted or that whatever they did was the right decision or the law. He thought that the criteria they were using were just not there on the face of the opinion they were writing, so that there was more like American opinions looked more like French judicial opinions, where the real reasons for the decision are concealed, but presumably both the Cour de Cassation and the U.S. courts are using some normative criterion for reaching their decisions.
My question is also for Luis. One thing in your perspective is, well, I think that you are saying two different things. One is that, well, since it could be that to have a concept of law, a doctrinal concept of law, means that first we are determining what the law is, and after that we are doing what the law requires. Since in an interpretive view of law, this is not what we are doing, what we are understanding, what the law requires, then it seems that we don't need a concept of law. But another very different thing is that, well, when we are speaking about the concept of law, in fact, it's one way of speaking, because we are speaking about a dominion, a particular dominion, and a special dominion of morality, since Dworkin is saying that, well, law is part of morality, but of political morality, but it is a distinct part. Then, if it's a distinct part of political morality, this doesn't mean that a judge, when is interpreting the legal materials in a process of making them to be law by means of balancing different reasons or values that are relevant in the legal domain, what we could say the internal morality of law, that, for example, I think that Fuller has said very interestingly. Then here, what characterizes the dominion of law is the freedom he has, or she has, in order to get the balance of these values, but also the restrictions he has in order to do that. Then it seems that a judge would identify law only with all things considered judgment, would be a very bad judge, because in order to understand what does it mean legal adjudication and not adjudication barely, the judge needs to understand this idea, or from the Dworkinian perspective, this idea of unifying formal and substantive values. And this is the product of law, trying to make this kind of unifying exercise of different kinds of values. And if we don't understand law in that way, then law is going to be something that diffuminates in deciding what is the better thing to do, what is a consideration of all things considered judgment. But it seems that in this view we are not understanding what the law requires to judge us. No? One thing is to say that law is not what legislation does. Because, well, if law is a process of balancing values, then, well, these legal materials are going to be part in our process of balancing. But this doesn't mean that the concept of law is disappearing as a dominion of reasoning, no? I don't understand exactly why you think that law is disappearing in other kind of considerations.
So I think, so law, on the one hand, I'm an economist again, so I said, on the one hand, it's disappearing, and on the other hand, it isn't. So I'm perfectly content for someone to say, law is a part of morality as an understanding, understood in an evaluative context. Right? That is, there are a certain set of values, moral values, that we want to identify as the value of legality, and we can then ask whether particular governance structures are realizing or instantiating those values. And we might ask further whether particular systems, whether the theory of adjudication for the judges in those jurisdiction requires them to utilize, to deploy those distinctively legal values in deciding cases. But that seems to, so all those things can exist, but there isn't, and if the theory of adjudication requires that, then they're using law in some sense, as, in my terms, in that particular jurisdiction. But it's sort of supervenient on what's actually going on. And it might equally be the case that the best way to realize legal values is for judges not to use them or to pursue them, because we think they're going to get it wrong all the time or often. I think that about some of the justices of my Supreme Court, that typically when they think about moral values, they get it wrong, and I'd rather they didn't, because they're doing more harm than good. So it's not obvious that, right, if we accept Ronnie's position, that there's this distinctive sub-realm of moral values that we can call law. It's not obvious that the right way to structure your governance system, if you want those values realized, is to ask judges to decide cases in that by reference to them. Right? So as I say, I want to separate out this idea of what's evaluative and what it is that's happening within the governance structure.
Thanks. Louis, my question concerns your effort to enlist Dworkin into your cause. I think he would have to resist your view for the following reason. I think that all the arguments you gave in favor of the dispensability of the concept of law extend more generally to talk of the state's requirements, or the requirements of whatever community promulgates the law. I mean, just as you said that the various legal officials or citizens could move straight from the materials to the judgment, or they could at the very least skip over the proposition that the law is so-and-so, so too, for the very same reasons, on your view, they should skip over the proposition that the state or the community requires such and such. But on Dworkin's view, the proposition that the community requires provides both the reason for obedience. I'm referring specifically to his associative theory of obligation. The fact that the community or the state requires it is the source, both of the reasons it gives the various citizens and officials reasons, and it also justifies the coercion that the state or the community exercises. So it plays an essential, indispensable, normative role in his view and in the view of others who have different versions of associative obligation. So I'm wondering if you are happy to just get off the associative obligation bandwagon and say that and say that, you know, the normative effects will be explained in other ways that that allow you to do without the concept of the state's requirements, or whether you will try to salvage this idea of the community requirements and just distinguish that concept from the concept of law, or perhaps some other gambit.
Well, I'm not sure I like the characterization of what I'm about to do as a gambit. Right? Queen's Gambit declined, is that? So I haven't actually thought about this. My inclination would be to abandon associative obligations as the source of the normativity. But I need to think about it more. And I mean, Ronnie, in a very much earlier incarnation of this argument, much less clear, I think, he rejected the view that his view was my view, right? So I'm sure he's disagreeing right now. And regardless of whether it is his view or not, I guess I think it's the right view, so I'll stick to that.
So, Luis, I don't have a question for you.
Okay, good.
So, what is it to grasp a concept? So my question is this: what is it to grasp a concept as opposed to interpreting a concept? Is it like perceiving colors? If it is like perceiving colors, then most controversies about concepts would become meaningless. So I have the impression that grasping a concept entails kind of situating that concept in a larger framework of convictions, what means that at the end of the day it is the same as interpreting the concept. And if for the sake of the argument, we assume that there is really a difference between grasping concepts and interpreting concepts. What difference would that make in terms of what courts should do?
Thank you. Yeah, my idea is that actually grasping the concept of law requires grasping the concept of having a whole idea of the law. And of course, in my mind, this idea, the very background is the idea of justice. Without that, you will not be able to not interpret the concept, but interpret the acts or the practices or the actions you take within that practice. So my idea is that you got to have an idea, a sense of the whole. And a sense of the whole of the law means you know what the law is for instance. That's basically what I'm saying. If you know that, then you're going to be able to interpret statutes and situations in particular. That's what I was trying to say. I think in a way, modern tradition has dispensed this idea of justice, of having a sense of the law, and that's part of the problem we are facing. If we have the sense of the law, let's say a positivistic sense of the law, law means a command, an order. If you know who's in command, you know what the law is. And then you always have to ask the person who is in command, if this practice does not have a sense in general, you always have to ask someone else, some authority, what to do. And when the case is difficult, then you have to refer it to the authority. That's what I was trying to say. You got to have a sense of the law in that respect. That would be a sort of concept of law. And I think when we read Dworkin in general, I think that's the way he made throughout his life. So he finally explicitly said that actually knowing the law is having a concept of justice. You got to have that. Even if you can discuss the concept of justice, you cannot do without the concept of justice, which is always equality, following rules, all these things that maybe were in nuce in Lon Fuller's account of the morality of law, the internal morality of law. But that's what I was trying to say. You got to have this sense. What are we doing here? That's the question. This sense, this is grasping the sense. This is not interpreting in the strict sense. If you don't grasp that, even if you make mistakes occasionally, you got to have this sense. And if you make a mistake, then people are going to ask what you did, and you're going to explain. Then you yourself maybe you're going to say, well, I was wrong. I made a mistake. The Supreme Court does that from time to time. We decided that case, but maybe we should decide it differently. So that's what I was trying to say. Grasping is this, having the concept of the whole practice, like using Wittgenstein's idea of the game. Are we playing soccer? Are we playing tennis? These are different games. Do we know what we're doing here? So that requires having a general sense. Okay, that's very simple with it.
There are 3 more questions, and we have 8 minutes for discussion. So if you can be brief, there is Roberto Saba, Rob Hose, you two, and Joaquin Millón.
My question is for Sabinato, too. I'm interested in your descriptive part of the presentation in the paper. You said that there was a moment in the past when lawyers thought that interpretation was not required, and that there was a change, and you connected that change, I understood, to the constitutional justice and the contribution of constitutional justice to the idea of interpretation, or that's what I understood. My first question is this account of a chronological history, let's say, interpretation, is correct, or whether in Brazil, I'm thinking about I'm curious about the Brazilian case, of whether this idea of interpretation that is behind constitutional justice operates only in the realm of constitutional justice and has not touched the interpretation of statutes or codes, and whether these two ideas of interpretation are kind of competing in your country and your legal system. The second question is short. I mean, it's about a comment you made about in Brazil interpreting Dworkin in a way that it triggers some sort of skepticism, because if everything is subjected to interpretation, then it sounds so far, to me, removed from what we understand Dworkin, and I wonder even if Ronaldo has anything to say about that account in the Brazilian context.
Maybe we can collect all the questions and then you can answer, please.
So, you know, I've found this discussion really interesting because, Louis, I've been struggling to understand exactly what you're trying to do with this project. So, I mean, this goes, I think, to Jed's question and also to some extent to Maurice's. My understanding of Dworkin's project is that it's actually a political philosophy that places adjudication or judgment somehow at the center of the normative enterprise. And I don't see, I mean, somehow your paper seems to me to detach a certain set of questions about institutional roles from Dworkin's political philosophy, which, you know, as Jed mentioned, in some sense really fundamentally derives from a concept of associative obligation, but also has elements of substantial political morality, equality, dignity, freedom as part of its structure. And you know, I'm wondering what I mean. Maybe I just misunderstood your project. I mean, you seem to be interested in how we understand institutional roles in relation to, you know, to legality or legal material. But I somehow see the Dworkin project as something much more sort of you know, thoroughly you know, normative, where the question of institutional roles is really derivative from this political you know, philosophy. So I guess my question, because I should be brief, is why launch this project in relationship to Dworkin's thought, as opposed to just launching it as you know, as your own project to understand institutional roles in relation to the way we talk about legality and legal material?
My question is to Reinaldo de Lima Lopez. The first question is related with your idea, with your title and the things that you are saying related with that title. The problem is if only experts can't or don't need interpretation, and they are the only people who can grasp meanings or the meaning of the statutes, it sounds to me very difficult how law can accomplish its guiding functions. And of course there is a normative question related to that. There is quite an elitist view about the law. The third question is a conceptual one, and it's related with Montero's question, is what you understand by grasping the meaning. If you think that grasping the meaning is sharing some background of judgment, as probably you think, the problem with that is that you will need to face Ronald Dworkin's idea of disagreement, because people might have deep disagreements on that thing. And even when people do agree about the canon of interpretation, I mean, many people can agree about how interpret some law or some statute with a literal canon, for example, but they might have a disagreement about why they are doing that. In some sense, they might have a different theory about what justifies the literal canon. That's the question.
Okay, yeah, well, these are the answers, these are the questions that I'm trying myself to answer, so it'll take some time. But trying to be brief. In the history of interpretation, Roberto, what I think, my previous work was on the idea of justice and how this idea of justice was dismissed from the legal field. And that, I think, was an important phenomenon or historical event. In the 20th century, basically, lawyers were convinced that justice had nothing to do with the law, or had very little to do with the law. This is part of the history. So we dismissed the idea of justice. So dismissing the idea of justice, that's my point, what I'm trying to investigate. We dismissed the very sense of the law, what brought law to have a unitary sense, even if people would disagree. But they would disagree about justice, but they knew they were discussing about justice. So they would say, you're wrong, we have to clarify that, but they knew what they were talking about. So I believe the problem with interpretation has to do with this loss of the meaning of justice. When you read Savigny, for instance, he doesn't refer to justice at all. It's very technical, it's very methodological only, and you're not going to need this idea of justice anymore. I think that's what happened in general. I'm trying to investigate. I don't have the answer yet, but I'm trying to investigate in that sense. First thing, I don't know if that satisfies you, but that's the way I'm going. And the other thing is about the Brazil. Yes, I think but that was mentioned also in Ronaldo's introduction to his paper. That is, people are talking about Dworkin, but they are not really doing what Dworkin did. So they're picking phrases of Dworkin, like justice, for instance. But the question is, what is justice after all? Is this a serious discussion we have to entertain among ourselves? Should we discuss that? This is one of the things that's happening. So they're using Dworkin and this interpretive perspective to say, well, this is our interpretation. And then arguments are made rhetorically in the bad sense of rhetoric. So sophistry is coming in, strangely enough, under the disguise of being Dworkinian. I think this is wrong, but I think this is the fact. This is the fact. This is the, I would say, the environment in which we are working there. Has it touched? Now, the problem is the seriousness of interpretation and of grasping the sense of things. Is it touching other areas of law? I think it is. We're having discussions about the constitutionality or the constitutional aspects of private law. I don't think it's being done, it's being well done, but it's being done. So this is why also part of my project is historical. Let's revisit what we have been doing in the last decades or maybe century. That's my project. That's working in Brazil. I remember our friend Kelsen in Bogota. So we're working in Brazil, Kesler in Brazil, working in Brazil. That's part of the problem. Now we have to discuss that. My point is exactly, if we have this, you may have this disagreement, because we are disagreeing about the sense, the fundamental sense. Can we disagree about that? Of course we can disagree about that. But my question is, can this disagreement be so widespread? No, otherwise we couldn't be doing things together. There would be no cooperation. So there must be something we take for granted And that's where, again, Wittgenstein comes in. So you got to take something for granted, or even Gadamer, to start a discussion. That's where I'm going through. It means, of course, you can have theoretical disagreement, but even when you're having theoretical disagreement, then you know there's something in common you're looking for. And of course, if law doesn't grow on trees, then what you're doing is you're building the common sense, the shared sense you're going to have. That's the basic idea. Thank you.
Okay, I will be brief. So that was a very helpful restatement of some of the earlier comments. So I've obviously failed at my most immediate aim, which was to get us to stop talking about the concept of law.
We keep our jobs.
So, right, Ronnie has a very well-developed, elaborate political philosophy. But he's also offering us, it's a very interesting one and has many interesting normative features, right? And understood that way, I'm perfectly fine with it, right? So his theory of law in that context, I would treat as a evaluative theory of, I might object to it on its own grounds, but he offers it not just as a political philosophy, but as something that's supposed to bear on actual practice in functioning governance systems, which in some sense is what the concept of law debate is about. It's about what's happening in these actual functioning systems, and it's supposed to help us, the political philosophy presumably is supposed to help us both evaluate and design, and this is in part drawing on Ronaldo's reference to the difference between the engineer and the scientist, the physicist. It's supposed to help us do that, and my view is what he's doing is aimed at, as he told me at one point, is meant to be saying something about actual legal systems, about actual practice. And I think he isn't, and that to say something about them, you need to pay more attention to institutional differentiation. So, that's it.
Okay. Thank you. Thank you all for your wonderful presentations and discussion. Let me share with you that there is just arrived this book of Ronaldo Portomacedo. It's about Dworkin's work, del ajedrez a la cortesía, Dworkin y la teoría contemporánea del derecho, is published by ad hoc. Okay. Congratulations.
Yes. The sense of law instead.
I'm not going to be happy.
No?